of webinars to keep all of you up to date in light of all the changes going on with healthcare reform, along with all the things you need to do to remain compliant. One of the biggest things that we're seeing in the marketplace is an increase in Department of Labor audits and the need to be more compliant than ever. So today we will be going over a HIPAA privacy overview that will also qualify, as Stacy will mention, for your annual training. This is a really important item, and we're glad for all of you that can join, and for those of you that cannot join today, this is being recorded, and you know, hopefully you're listening to it. We're at a quiet moment where you can really understand it, and then follow up with us if you have any additional questions. Stacy, next slide. Stace?
Yep.
Next slide. Is it going?
Going for me.
Okay, well, maybe my old one. One of the things we just want to remind everybody is if you have any questions, feel free to email us or text me. We're going to have the opportunity throughout the meeting to continue to provide input questions to Stacy. We have a lot to cover today, but we want to make sure that we address any issues or concerns that you may have. Okay, so I'll turn it over to you, Stace.
Thanks, Richard. And good morning, everyone, or good afternoon. This is Stacy Barrow from Proskauer Rose in Boston. And Proskauer is proud to partner with Silverstein Insurance Group to offer this series of webinars to their friends and clients. As Richard mentioned, today is the annual HIPAA training webinar. We're going to go through an overview of HIPAA, talk about the pertinent aspects that apply to employers that sponsor plans that are subject to HIPAA. And this will satisfy the HIPAA training requirements. We do present this webinar at least once a year. There's not an annual training requirement per se, but we do this webinar once per year because as you hire new people into your HIPAA workforce, you are required under HIPAA to provide training within a reasonable amount of time after their date of hire. And so it's generally accepted that if you do this on an annual basis, you'll pick up any new hires, and we'll also address any changes in the law since last time as well. So if you are using this webinar to suffice as your annual HIPAA training, we just recommend that you print out today's slides and then have a sign-in sheet. You note the date and that it was presented by Stacy Barrow at Proskauer, and have everyone sign in, and that will suffice as your training. So we'll start out with an overview, and we'll talk about the entities to whom the rules apply, different penalties, and then we'll get into some of the specifics, including what is protected health information and other selected topics in HIPAA privacy, including the new breach notification rules. So by way of background, HIPAA's been around for a while now. It was first enacted in 1996. We saw privacy rules originally come out in late 2000, and they were amended again a couple of years later. They were relatively untouched until 2009 when ARA was passed into law, the American Recovery and Reinvestment Act, and that made changes in the form of the HITECH Act, which give us our breach notification rules under HIPAA. That was the most recent change up until last year when in January the HHS released what they're calling the Omnibus HIPAA privacy regulation, which basically amended and restated HIPAA. It gave us regulations on the breach notification rules that were part of HITECH, and it also implemented other changes that were required by GINA. The Omnibus rule was effective in March of 2013, and covered entities had until mid-September to comply. And those of you with self-insured plans who are responsible for sending out privacy notices may recall having to do that again at some point last year. There was an additional year to get into compliance with certain business associate agreements that were in place on January 25th of 2013. You have until this September to bring those business associate agreements into compliance unless they were opened up and amended within 1 year before that date. The HHS recognizes that some employers spend a lot of time negotiating these business associate agreements, particularly with their TPAs and other vendors, and so they gave that extra year for employers before they have to open them up and amend them again. So which entities does HIPAA apply to? HIPAA applies to what we call covered entities. So they apply to employer-sponsored group health plans. They apply to what they call healthcare clearinghouses, and they also apply to providers. And the rules will also apply in part to a plan's business associates, but the organization itself that holds the information or that has the information is not directly subject to HIPAA. So as an employer, you're not subject to HIPAA, but your health plan is, your group health plan, and particularly if you have a self-insured group health plan, you are fully and completely subject to HIPAA. If you're fully insured, a lot of the issues are taken care of for you by the carrier. You may not come into contact with protected health information that often, but certainly if you're self-insured, very critical to have full HIPAA privacy policies and procedures. So what qualifies as a health plan under HIPAA? Generally, any employer-sponsored group health plan is going to be a covered entity under HIPAA, including a health FSA. There's an exception for small plans that have less than 50 participants and which are self-insured and self-administered. So this could affect or could apply to some employers that have small health FSAs that they administer in-house. But for the most part, if you have a major medical group health plan that's self-insured, you're not going to qualify for this exemption because, one, you're going to have more than 50 participants, and two, you probably will use a TPA. The carriers and HMOs are also health plans under HIPAA, and the fact that you have fully insured plans, they are still subject to HIPAA, although the carriers will take care of some of the requirements, including the maintenance and delivery of a privacy notice. So not all employer-sponsored group health plans are subject to HIPAA. Not all employer plans are subject to HIPAA. Plans that are not health plans, like your disability, accident policies, life and AD&D are not covered by HIPAA, as well as workers' compensation benefits. All these non-health care related benefits are not subject to HIPAA. So in general, the types of benefits that are subject to HIPAA, the types of employer-sponsored plans, include your major medical plan, but they also include dental, vision, hearing, mental health and substance use disorder benefits, and prescription drugs. EAPs that provide counseling also are generally considered health benefits under HIPAA. Always makes sense to spend a couple of minutes just running through the penalties really quickly. When you see this chart here, the original HIPAA law only contained the first row of penalties, the $100,000 to $50,000 range, and the penalties were criticized by some as being too lenient, where if you're a major, large corporation, a penalty of $50,000 might not encourage you to be fully compliant with HIPAA. And so in later years, and actually it was 2009 under the HITECH Act, these penalties were increased and expanded based on the type of violation, and they can go all the way up to $1.5 million per year. And in addition to HHS being able to assess penalties, state attorney generals also have the ability to enforce HIPAA. And so we're starting to see more action from the state AGs when they realize that even for potentially relatively minor HIPAA violations, substantial penalties can apply. And so while HIPAA does not provide individuals a private right of action, meaning that you can't sue if your HIPAA rights are violated, you can potentially complain to the state, and the state AG could look into that, and the state AG does have the authority to assess penalties.
Hey, Stacy, are the penalties deductible or non-deductible?
I'm not sure, actually. They're not tax code-based penalties, so I would expect that they would be deductible, but I can look into that after the webinar and run that down.
We'll have that as a follow-up for some of our folks. I know that CFOs always want to know, well, if I pay a penalty, is it deductible or non-deductible? So thanks for the follow-up. Okay.
And here we just have an example of a couple of relatively recent breaches. One of them happened up here in Massachusetts where I practice. This one got a lot of press. An employee of a hospital left his laptop on a train on the way home, and it was unencrypted, and it had a lot of patient data, thousands of lines of information, and that ended up requiring the hospital to settle with HHS for over $1 million and provide retraining and things like that. It was fairly embarrassing for the organization. And these things do happen fairly regularly. A lot of times it does happen when you have unencrypted laptops or USB keys. Those are things that are ripe for a breach. I'll talk a little bit later. Yes?
Stacey, we have a lot of folks on the phone that are not health systems or that are private employers. I know we'll cover some of the examples, but is there anything out there that you could recall that is, let's say, not as an employer violation that resulted, or is there anything that when you've talked to folks that through the compliance audit is the best example of where you could really get hurt?
Sure. I mean, we certainly run into HIPAA issues where employer clients, not just the big hospital systems, will have employees that have access to PHI, and they'll have it on a company laptop or potentially even their own laptop, or they transfer it to USB key, and then the key is lost or misplaced. Those types of issues affect employers as well. We've seen those from time to time. And kind of surprisingly, I guess, a lot of times where we see issues occur is with health FSAs. Health FSAs obviously subject to HIPAA. We do see a lot of employers self-administer them, and when you're self-administering those types of plans, there are more avenues for breaches. If you're sending out the EOB type of statement, there's just more of an avenue to send it to the wrong email or accidentally get two copies stuck together, and then one person gets the EOBs for both participants, and that actually happens all the time. We run into clients that this happens to fairly regularly, even though they have processes in place to protect against it. And just when you are a large company and you do this multiple times every day processing these claims, you are going to get hiccups from time to time.
Okay, thanks for information on that.
So we talked about covered entities. Those are essentially the employer-sponsored group health plans for purposes of today's call. And so now we're moving on to PHI. And so what HIPAA protects is PHI. And so we're going to define PHI, and this is really a loaded term here. it breaks down into a number of components. So PHI, first and foremost, is individually identifiable health information. And we're going to talk about that particular term on the next slide. So one, it has to be individually identifiable health information, and it can be in any form. It can be written, it can be oral or electronic, but it still can be IIHI, individually identifiable health information, which is a broader category of protected health information. PHI is a subset of individually identifiable health information. So once you've determined that you're dealing with individually identifiable health information, it will be PHI to the extent that it is created, maintained, or received by a covered entity. And so as an example, PHI excludes employment records held by an employer in its capacity as an employer. And so one example we always use is that your company may have a policy that says if an employee is absent from work for more than 3 days, that they need to get a doctor's note saying that they're fit to return to duty before they can come back to work. And so when the employee comes in and he brings that doctor's note and hands it to his manager, that is an employment record, and while you should treat it confidentially, it's technically not protected health information. And then one little change under the omnibus rule, they have confirmed that covered entities must protect the PHI even of deceased individuals for at least 50 years. So again, PHI is individually identifiable health information that is created, maintained, or received by a covered entity. So what is health information? We'll talk about what makes it individually identifiable on the next slide, but we're going to break it down into its component pieces. So health information includes any information that's created by a provider or a plan, an employer, school, or university that relates to the past, present, or future physical or mental health or condition of the individual, or the provision of care, or the payment of care, and that includes past, present, or future care. So what makes this health information individually identifiable? There are a number of identifiers. I think there are about 19. We probably collapsed a couple here, but here are the pertinent ones. And so things that are obvious that make information individually identifiable include information like names, socials, other account type numbers that can identify people, email addresses, even ages over 89 are presumed to make health information individually identifiable. So if you strip your health information of all these identifiers, then you can create summary health information, which is not subject to the same standards as the PHI. So what are examples of some PHI? Claims-related information, EOBs, calls from employees to the plan. This is all PHI. Summaries of claims information that include the identifiers that we just talked about, that is also PHI, as well as a list of plan participants that comes from the plan. The enrollment and disenrollment information has somewhat of a dual status under HIPAA. It is PHI when it's maintained by the plan, but it's not PHI when it's in the employer's hands. So again, examples of things that are not PHI are the doctor's notes that are provided to managers, information contained in FMLA or ADA requests, because those are not covered entities under HIPAA, and then the de-identified, the completely de-identified claims information is not PHI. So what are the basic rules of PHI? The basic rule is that as an employer sponsoring a self-insured group health plan, you can use PHI basically for for payment and operation of the plan. You can also make disclosures for treatment purposes, but this is typically not what disclosures are made for with respect to employer-sponsored plans. Usually, we're disclosing the information for payment purposes or for health plan operation purposes like underwriting, plan design changes, things like that. Any other use or disclosure of PHI requires a signed written authorization from the individual who is the subject of the PHI. We'll talk about some of these individual rights in a few minutes, but there are a number of rights that individuals have, including a right of access to his or her health records that are maintained by the covered entity, even a right to propose certain changes in certain very limited circumstances, which we'll talk about. And then the other basic rule under HIPAA is that you need to have a training, which we're doing today. You must appoint a privacy officer and develop a privacy notice to the extent you're self-insured. So again, the types of uses and disclosures that can be made without any written permission include treatment, payment, and health plan operations. And again, from an employer standpoint, it's typically for payment and operation purposes. So you can disclose enrollment information either to use it internally or disclose it to the vendors, obvious things like that. Same with eligibility. You can use it internally. You can disclose it to the vendors. You can also disclose it to providers when they want to know if someone's covered under the plan. Other types of case management, disease management, utilization review, coordination of benefits, obviously adjudication and payment of claims. These are all permitted uses of PHI, and you don't need to obtain anyone's authorization to go ahead and use that information. So as mentioned, key requirements include the training, which we're doing today, the establishment of a privacy officer, development of a privacy notice, the maintenance of an authorization form in the event that you ever do have employees that may request for you to help them with claims issues. You usually need an authorization for that. Adherence to the minimum necessary standard. This is one of the more important concepts in HIPAA. We'll talk about that in a few minutes. The implementation of administrative and physical and technical safeguards, also another big requirement under HIPAA, as well as giving everyone their rights as individuals, having business associate agreements with their vendors, and then having all kinds of policies and procedures in place to deal with employee complaints and then sanctions for employees that may violate your policies on PHI. So I mentioned this earlier. Training is part of the requirement, and the requirement is really that the employer must train its HIPAA workforce or its HIPAA personnel within a reasonable amount of time after date of hire, and so that's why we tend to offer this on at least an annual basis. And again, just to make sure everyone documents this, you just want to have a sign-in sheet for today's webinar, document who attended, and then staple a copy of these slides to the back, and that will suffice. Under HIPAA, all group health plans have to appoint a privacy officer. This generally applies to fully insured and self-insured plans. The privacy officer is ultimately the one who's responsible for implementing the privacy and security policies and procedures. And you also have to designate a contact person. For many smaller employers, the privacy officer is the contact person, but if he or she has a subordinate that reports to them, they can have their assistant or their associate be the contact person as well. And they should just understand that when there is a HIPAA issue that comes in that they're notifying the privacy officer of, the contact person must inform the privacy officer immediately when a call or an issue arises.
Hey, Stacy, quick question for you. We have a lot of folks where there's a turnover in HR and somebody comes in that was the privacy officer, and so they name somebody else. Is there some best practices in saying to that new person, it'd be good to listen to this recorded webinar, read this PowerPoint, sign off that you have that from a training standpoint, or is that really not necessary? So I'm just curious your view on that.
No, I think that's a good idea, particularly if the new hire is going to be someone who really is going to be heavily involved with PHI. If it's someone that is rarely, if ever, going to touch it, and they're going to get picked up in the next annual training, and it's only a few months away, maybe they don't need to sit down and listen to it right away. But if it's someone that's going to be heavily involved in HR, sure, they should, at the very least, receive a copy of the plan's privacy policies and procedures, sign off that they've received it and read it, and I do think it would be a good idea for them to sit through the training sooner rather than later.
Okay, thank you.
Privacy notice. The most important part of the privacy notice is that if you are fully insured, it is the carrier's responsibility. Otherwise, if you are self-insured, including having a health FSA or an HRA, both of which are self-insured group health plans subject to HIPAA, then you must maintain a privacy notice for that plan. The distribution requirement is it goes out to all new enrollees in the plan. This is one of the few notices that require an affirmative consent for electronic delivery. You probably are all familiar with ERISA's rules that say you can email a privacy notice, you can email SPD and other ERISA-required documents to anyone that has email as an integral part of their job duties. The privacy notice is a little different. From an employer standpoint, you really either need to mail a hard copy of that notice or obtain affirmative consent to electronic delivery. You can obviously post a copy on your intranet as well, and in general, we don't see these privacy notices having to be updated all that frequently, although we did just have a major update because of the omnibus rule that was released in 2013. But in general, unless you have made amendments to your privacy notice, you don't need to keep sending it out on an annual basis. You just need to remind your participants at least once every 3 years of the availability of the privacy notice. The notice itself can be anywhere from 5 or 6 or 7 pages, and so every 3 years you don't need to send out a new notice. You just have to send out a little blurb that says if you do want a copy of the notice, we maintain one. Please contact the plan administrator for a copy. And that disclosure can be made electronically, and some employers just drop it in their SPD just so they don't have to worry about tracking whether it's been 3 years or not. A bunch of information or a bunch of changes that were made by the omnibus rule. Most importantly is that a covered entity must disclose in its notice of privacy practices that it will notify any affected individuals of breaches of unsecured protected health information. Other more minor changes include that authorization will be required for sales and marketing of PHI. Uses and disclosures that are not described in the notice will only be made with an authorization. And then this is for providers, not really for employers, but that individuals can restrict disclosures to their plan for services for which they pay out of pocket. And this really just applies to providers, not to the employer-sponsored group health plans. Other changes affect plans that underwrite. They must disclose that genetic information will not be used for underwriting purposes. Covered entities that engage in fundraising, again, this typically does not apply to the employer-sponsored plans. It's more for the carriers to comply with. basically individuals will have a right to opt out of fundraising notices to the extent that the covered entity maintains psychotherapy notices, or sorry, psychotherapy notes. The notice must describe that. Most disclosures of psychotherapy notes will require authorization. And then to the extent that the plan does not maintain a website for the plan, or the employer doesn't maintain a website for the plan, and the privacy notice is not posted on the website, you must notify participants within 60 days of the date of any change to the privacy notice. Most of the time, it's going to result in a new mailing. So moving on now to some of the individual aspects of HIPAA. Again, you can always use PHI for treatment, payment, or healthcare operations. Any other use or disclosure is generally required to be authorized by the individual who is the subject of the protected health information. Written authorizations are always recommended, and often this comes up when you have an employee who needs help with a claim issue. They might come to HR and they don't understand the term of the plan, or they received a denial notice and they don't quite understand why, and the HR person is going to help them and contact the plan. You should just obtain a signed authorization from that individual before helping him with that issue. Other example, if you are administering, say, a disability benefit, say short-term disability, and you have an employee who puts in a claim for benefits under the STD policy, and you want to check to see if he really did see the doctor and what his condition is and whether he is fibbing about it, you still need an authorization for that. A lot of STD and LTD plans will contain, as part of the application process, an authorization to say, look, if you would like to apply for benefits under this plan, you need to authorize us to obtain your medical records so we can properly adjudicate the claim. Individuals from time to time will also ask for assistance with benefits with respect to family members, and this rule really permits you to use your judgment, basically. If the disclosure is to a family member that's involved with the care, and the individual has not objected to disclosure to family members, then it's generally okay to disclose PHI to the family member. It's always best to have an authorization in place, or if they have another legal document such as a healthcare proxy or a general power of attorney, then the employer can generally disclose any information to the family member that has obtained an authorization. In terms of what you can discuss, you can generally pass on information from a spouse to the plan, or to the vendors if it's for purposes of payment. You can typically discuss medical claims of a minor child with the parents, although you should consider the facts and circumstances. There may be laws limiting disclosure of information regarding family planning or abortions, things like that. If there are instances of domestic abuse, then it may also not be appropriate to discuss those claims with the parent. And you can typically disclose PHI to family members of deceased participants as long as you didn't have any prior knowledge that the individual has objected to that kind of disclosure. This rule is probably the most important rule, or one of the most important rules under HIPAA, and that's the minimum necessary rule. Whenever you make any disclosure of PHI, really regardless of the reason, you should make reasonable efforts to limit the disclosure to the minimum necessary required to accomplish the intended purpose of the disclosure. So, if you don't need to send the entire claims file to help resolve an issue, then you shouldn't do so. You should always disclose the minimum amount possible. There are a couple of exceptions. If you're making disclosures for purposes of treatment, then you don't need to worry about the minimum necessary standard. Same thing with disclosures due to a signed authorization from the individual. Then you can disclose anything that is authorized under the form. Disclosures to the government when there's a subpoena or other judicial action, and then other disclosures that are required by law also do not have to follow the minimum necessary rule, but these will be pretty rare except for the treatment or the authorization. So you should always have that in the back of your head, that when you're making a disclosure of PHI, unless it's for treatment purposes or pursuant to an authorization, you should have or disclose the minimum necessary. You also need to limit access to PHI, and part of this is identifying which members of your workforce will need access to PHI in order to perform their job duties. And these folks are referred to as your HIPAA workforce, and this will include your privacy officer, members of HR to the extent they handle benefits issues, and then members of IT that may have access to PHI. I had a client ask recently, well, can't we just identify our whole company as part of the HIPAA workforce, so if someone accidentally sees some PHI, then they will be there won't be a breach because they'll be part of the workforce, and we won't have to report it. And the answer is that you can't really do that. The HIPAA workforce are only those people who require access to PHI to carry out their job duties.
Hey, Stacy, what's an example for those on the phone when you think about the IT department? And then what about people that outsource IT and probably having a VA agreement if those people have access?
Sure. So probably not too unlikely that members of your IT department may have access to areas of your servers that contain PHI. You should do your best to limit it to people. Maybe the entire IT department doesn't need that access, but there'll be at least one manager over in IT that will just simply need access to the entire server to do maintenance and updates and get it online and things like that. And so those folks that have to have that access, they should also be considered part of the HIPAA workforce. And like you said, to the extent that that is outsourced, you would need to have a business associate agreement in place if the vendor is performing services on behalf of the plan. This does come up when you have a PHI that might be maintained on a cloud, and you have a vendor that manages that cloud. They would typically be a business associate, but it does really depend heavily on the facts and circumstances. So folks that are listening, if you think this might apply to you, you should talk to Richard or someone from his team, and we can assess exactly how this rule applies to you.
Okay, thanks for your information on that. That's good.
So again, only the HIPAA personnel can have the access to PHI. Anyone else should avoid seeing or using protected health information. And of course, you are limited to your use of PHI for only the permitted plan functions, and you should always limit the PHI that's disclosed to the minimum necessary. And then, of course, the HIPAA personnel cannot disclose PHI to any other employees other than the HIPAA personnel who have a need to know the information. Just a little reminder here, please do feel free to send us your questions via text or email. So moving on now to the safeguards, HIPAA requires there to be basically 3 types of safeguards: administrative, physical, and technical safeguards. And so we'll discuss some of them here. Typically, you do not file protected health information in the same folders as other HR type of information, where the HR folks will have access to it when they're not members of the plan's HIPAA workforce. Other, basic common sense kind of things that we probably all have in place. To the extent you have paper protected health information, you want to keep it behind closed doors in a locked cabinet. Always have screensavers and password protections on any computers that have access to PHI. And then when you are, if you're discussing PHI with other members of the HIPAA workforce, you want to do so only in a controlled environment. And even if you are a member of the workforce, if you are not working on a particular issue and you have no need to hear what's going on, then you should not put yourself in a position to overhear a discussion of protected health information. So individuals have a number of rights under HIPAA. I'm going to skip through them in general because in my experience over the last 15 years or so of doing this, we rarely have clients that have employees who request access to their PHI. A lot of clients really don't even have or maintain this information as something that's maintained at the TPA level or the carrier level. But at any rate, they do have a number of rights. These are all described in the privacy policies and procedures. But again, it's very rare that you see an enforcement of these rights. So I'm going to kind of just move through them very quickly. Individuals do have a right to propose amendments to PHI that is created by the plan. You can't, as an individual, you can't go to the doctor's office and then disagree what he wrote in his attending physician statement and then require the plan to amend it. That's not how it works. It would really be a correction of information maintained by the plan. Maybe they misspelled your spouse's name, and so you ask that they correct the spelling. Employees or participants can request an accounting of disclosures that were made for other than purposes of treatment, payment, or healthcare operations. Individuals have a right to request confidential information or confidential communications. Out of any of the individual rights, this might be the one that's most likely to happen from time to time. You may have participants that are going through a divorce or potential domestic violence issues, and they will request that EOBs be sent to alternative locations. And generally, you do need to comply with this. And if you ever do get one of these requests, it should be elevated immediately to the privacy officer, and they can discuss with Richard and his team and come to a consensus as to whether the request should be complied with. We talked a little bit about this during the other part of the presentation. As a covered entity, you're required to have business associate agreements in place with all of your entities that provide services on behalf of the plan. This will almost always include your benefits broker to the extent that they help you with underwriting and issues involving protected health information and marketing of the plan each year. actuarial services, accounting services, lawyers sometimes will be business associates of plans, particularly if they're helping with claims issues. Really anyone with access to health information about your plans should have a business associate agreement in place.
Hey, Stacy. Just came up the other day. Quick question is, we have people that account managers that send out BA agreements, and especially, let's say, for some of those that have smaller groups and they don't send them back. For those that are listening on the phone, what's your concern? What we're talking to folks about is making sure when you see somebody face-to-face, everybody's busy, get them to sign them. But your advice to us would be try not to operate without a BA agreement in place.
Oh, yeah, certainly. Certainly. I mean, it depends where the information is housed, but often if you're asking one of your vendors to disclose protected health information to the broker, they won't even do it unless you can show them that the business associate agreement is in place. And if the client is the one that houses the PHI, then they technically could be violating HIPAA if they are sharing the information without a business associate agreement in place. So it really is critical to have those in place and have a good, solid business associate agreement.
Okay, thank you.
Thanks. The Omnibus Rule also expanded the definition of a business associate to include subcontractors who also work on behalf of the plan or the business associate and create, receives, maintains, or transmits PHI. And so specifically under the Omnibus Rule, types of entities like patient safety organizations, what they call e-prescribing gateways, these are now entities that can be business associates to the extent that they're accessing and storing and sharing protected health information. You have to have very specific language in the business associate agreement. If you've ever looked at a BA agreement, you can see it looks more like a math test than a legal document. It's full of statutory and regulatory references, lots of numbers, different federal regulation references. And so, these are very technical documents. You should be working with counsel to develop them, but it's critical that you have them in place when it's required. The Omnibus Rule also expanded the application of HIPAA directly to business associates, including the penalties. So, to basically your business associates, like the brokers and consultants, they also now have direct obligations under HIPAA, whereas before they were only obligated to comply due to the contractual language in the business associate agreement. But now under HITECH and under the Omnibus Rule that implements HITECH, they are now directly regulated by HIPAA. A couple of changes regarding agency law. The Omnibus Rule kind of switches the way the liability is apportioned now. You can now, as a covered entity, as a group health plan, be liable for failures of your business associates. In the past, typically when a covered entity delegated a function to a business associate, the business associate would be the one on the hook if there was a failure, but now the covered entity can be reached when there are issues regarding one of its subcontractors or its agents. Privacy notice, of course, will advise all participants that they have a right to complain about violations of their HIPAA rights. They don't have a private right of action. They can't, proceed directly to federal court and sue you to enforce HIPAA, although, again, they can complain to the state and they can involve the state AG which does have the authority to bring action against the plan. If you are a member of your plan's HIPAA workforce and you are the recipient of a complaint, you should elevate it immediately to the privacy officer, and the privacy officer will check the privacy policy and investigate the complaint, and then make a determination as to what follow-up is necessary. And of course, you cannot retaliate against employees for making complaints. This slide here really meant more to kind of scare you a little bit into compliance, but the rules do require in your privacy policies to state that there will be sanctions, or there may be sanctions against the plan's HIPAA workforce if they fail to comply with the policies and procedures, and that includes possibility of termination of employment. We don't see this happen very often at all, and we would recommend if you think you're in a position where you have to apply a sanction to an employee, that you talk to Richard and his team and get us on the phone if necessary, and we'll run that down and see if that's the appropriate action. Another major component of HIPAA is that it requires the establishment of privacy policies and procedures. Everyone that handles PHI should get a copy of the policies and procedures. And so this goes to what Richard was talking about before. When you have a new hire and you're not going to give them the HIPAA training immediately, they should still get a copy of the policies and procedures if they're a member of your plan's HIPAA workforce. Remember, not everyone gets a copy of the full policy and procedure manual. It's only the folks in HR who are dealing with PHI as an integral part of their job duties. Lastly, before we finish up here and open it up to some questions, I just want to remind everyone that the Omnibus Rule changes the notice requirements for breaches of unsecured PHI. In the past, you could make a determination as to whether a breach of unsecured PHI resulted in a threat or a reasonable likelihood of financial or reputational or other harm, and that was your standard for determining if a breach has occurred. Here, under this new Omnibus Rule, they have basically flipped the standard, and they said a disclosure of PHI, of unprotected or unsecured PHI, is presumed to be a breach unless through a documented risk assessment you can prove or demonstrate that there's a low probability that PHI has been compromised. So in the past, where you could start off from the proposition that a breach was not reportable unless it resulted in financial or reputational harm, now the burden is flipped around and you have to presume that the breach is reportable unless you can demonstrate the low likelihood of the PHI being compromised. Whenever you have a breach of unsecured PHI, it is absolutely critical that you notify the privacy officer immediately, and you should call Richard and his team and really get on the phone with us as soon as possible after the discovery of the breach. You have 60 days to notify affected participants, but it's without unreasonable delay in no event later than 60 days. And so if you take 59 days to make the disclosure, you may end up having to answer to HHS or the state as to why you took so long to make the disclosure. You don't have the full 60 days in every situation. These are the 4 factors that the risk assessment must consider. The nature and extent of the PHI, how sensitive was the data, who was the PHI disclosed to, whether it was actually acquired or reviewed, and then what mitigation efforts were taken. These are all part of the written, documented risk assessment that must occur whenever there's a breach of unsecured PHI. And just remember, We talked about this before, but privacy breaches can occur in a number of ways, not just the physically lost or stolen devices, but little minor mistakes of messages left with the wrong person, misdirected faxes or emails, accidental posting of information to the internet, or failure to use secure email for transferring PHI. There's a bunch of content requirements for the notice. I'm going to just skip over these. The most important thing to know is that if you do ever experience a breach of PHI, you should be talking to Richard and to us directly as soon as possible to get the process and the responses rolling and to kick off the risk assessment. Just a few action items. You do need to report breaches annually to HHS to the extent you have reportable breaches. You either want to meet the safe harbor for treating PHI as secured or have solid breach notification policies and procedures in the event you maintain unsecured PHI. You need to update your privacy notice, get your BA agreements tuned up in light of the omnibus rule, as well as keep your policies and procedures updated and implement the training at least on an annual basis.
Thank you, Stacy. And I think one of the, just remembering a situation occurred where we had a TPA send an email to somebody at our client that probably picked the wrong person to send it, but it was the chief legal counsel of a public company, very large company, and it had other people's information in it, claims information in it. And so, with technology today, with what you're seeing with what's going on with Target and, information and being transmitted through the internet, it's just important that if somebody gets something, you hear of something, that you let us know and that you, elevate it from that standpoint, because I think we're going to see more and more of that, which is unfortunate. We're doing everything here at SIG to be compliant, send things through secure servers, having updated BA agreements, having this training. So I think that's the kind of stuff that you need to know what you need to do and how to be compliant from that standpoint. We don't have any questions at this time, and also we're getting ready to wrap up from the time standpoint. I just want to remind everybody that our next webinar is going to be the joint SIG ban webinar, and it's going to be it's the first part of two parts. It's the audit preparation part one, health and welfare plans. That's health and welfare plans. And then a month later, there will be one on retirement plans. Please continue to communicate to your SIG representatives, your account manager, account executives, whoever you deal with. If there's any topics that you would feel you would benefit from, that you feel we should add to our agenda as things change with healthcare reform, as there's information for compliance, as there are topics that you need to be kept up to date on, we can add that to the rotation. Also, for all of you that are self-funded, and for those larger groups that are fully insured but are considering self-funded or may want to go self-funded, there will be a seminar on May 8th. If you haven't received that notification yet from your account representative, you will be, but we'll be discussing transparency tools, telemedicine, and then an update on best practices in terms of disease management, closing gaps in care, employee education and engagement. So stay tuned from that standpoint. Hope everybody has a great day, great rest of your week. Again, if you have any questions regarding anything regarding HIPAA or compliance, feel free to get in touch with us. The one thing that we're blessed with is that we have a great relationship with Proskauer, with Stacy and Peter. We have a dialogue forum where we're able to ask unlimited amounts of questions and get your answers in writing, and many of you have benefited from that, so feel free to take advantage of that. Stacy, thanks again for your continued partnership. We are really glad to have you be able to do these type of webinars, and we get great feedback from our clients on them, so thanks again.
Thank you, Richard. It's always a pleasure to participate, and thanks, everyone. Have a great day.
Okay, take care. Bye.